There we go.
You're live.
Okay, great. Appreciate it. Tammy, we're on record. Let the record.
Yes.
Yeah, let the record reflect it's Tuesday, May 25th, 2021, and the board is convened to consider its docket for today and its other agenda items. We're going to call the first case now, which was set for 8:30. It's just a few minutes after 8:30. It's a Division of Industrial Compliance case, and it's case number 21-0049. And it deals with the Miami University Equestrian Center located in Oxford, and the division's adjudication order number is noted on the docket. Let's have an introduction of the representatives of the university. Then we'll do the same with the division. My presenter sheet indicates that I would just have Kevin Morris on behalf of the appellant, and now I see it's Yang instead of Mike Thompson on behalf of the division. But Mr. Morris, would you enter your appearance, please?
Yes, I am here, Kevin Morris, Miami University.
Go ahead.
Let me mute.
No, you're fine. I want to, in what capacity?
Mr. Morris, if you could spell your last name and then tell us, other than from Miami University, what are you actually an employee of Miami University, or are you the architect, just so that we understand your role?
My name is Kevin, K-E-V-I-N, Morris, M-O-R-R-I-S. I'm a project manager for the university. I'm the project manager for the Equestrian Center, and I'm here to represent the university's interests in this case.
Okay. And Mr. Morris, anybody else appearing on behalf of the university?
I also have on the line Joe Schmidt. He's with the architect. Should we need him, we can call upon him, but otherwise I'm hoping he's not necessary.
Okay, I did see him. If it becomes necessary, I'll have to individually have him sworn in. Okay, and then representing the division?
This is Yang Jiang, J-I-A-N-G, Plains Examiner Supervisor for the state of Ohio.
Okay, very good. Mr. Morris and Jiang, if you would rise, spell your raise your right hand, and Tammy, our court stenographer, will administer an oath.
Do you solemnly swear or affirm the information you are about to give in this hearing is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Morris, we will defer to you at this point in time.
Okay. This case is fairly simple. It's a matter of whether or not we have a horn as part of our fire alarm system. The building code does require horns. The issue we have is that the horns are prone to inducing panic in horses. And we're worried about false alarms causing situations where horses can panic and students or employees can get injured by horses. In a dusty environment, accidental or false alarms are perhaps more common as well. This is a singular large space. We have a PA system in it. We have strobes in it. We have all other protections. We are simply looking for the ability to disconnect or not have the horns functioning for safety of our students.
Very good. Questions of Mr. Morris by members of the board?
Yes, Mr. Chair, I did notice in the documentation that was provided that you're only requesting the non-audible notification in the animal areas only, and that other areas, offices, classrooms, and non-animal areas are still going to have the audible devices?
That's correct. Now, currently, classrooms are a vision for the future. We don't have them yet, but when we have them, that will apply. The only other spaces we have are restrooms, a storage room, and an electric room. And I guess it's questionable whether or not we need horns in there or not, but they'll at least be muted. A horse could probably still hear them, but they'd be muted in there, so we're okay with putting horns in those spaces. But the primary space is where the horses will be. And if we could at least get relief from having them in that space.
Okay, and probably just for so you're aware, we will probably add a, what we call a use condition, which means the building that you're showing us right now, we're giving variance to. If the building should change in the future, you would need to come back before the board, so.
Understood.
Any other questions of Mr. Morris by members of the board?
Yes, has anybody talked to the fire official?
Yes, we had, well, I don't know for certain. I'm pretty sure we talked to the local fire department. Actually, this whole request came from Rich Dusha. He's in constant, he's a representative of the university who is in constant communication with both the state fire marshal and the local fire officials. We did get Alan Smith's concurrence. There is a email where he indicated his support, which was part of the documentation that I provided, where Alan Smith was supportive of our proposal, and he was requesting relief from Mr. Eaton.
Who's, I'm sorry, I'm going back.
Alan Smith is a state fire marshal.
Okay, well, I still think you need a letter of no objection from the local fire official, because ultimately they're responsible.
I'm sure I can get that for you. I do not have it presently.
And that, if we find our way to a variance, that's likely to be a condition as well.
That's fine.
And the onus would be on you or the university, not the Division of Industrial Compliance, to secure that.
Understood.
Okay, let's hear from the division.
Yes, we do not have any objection over this. This is quite common for any kind of animal lab or show buildings, and this kind of situation occurs a lot of times. So we don't have any objections.
Okay, any questions?
No question, just like we discussed before, and any other area would have to have a horn strobe in there as required by code.
Okay. Sentiments or comments by members of the board?
I'm fine with it, with the conditions we've discussed.
A use and no objection from the local or the fire official having
Right.
jurisdiction.
Right.
If I may interject for one moment, I understand I'm getting a note from the architect who's also in attendance that we do have a letter from the local fire official. I will forward that to you or forward that to whomever you like after the meeting here.
Chip, is that something that we want to see if we can get emailed to Susan so that we can take a look at it right away, or is it all right to condition it separately?
If it can happen now, I'm happy to take a minute and.
Is that Mr. Schmidt that has a copy of the letter?
Yes.
Susan, why don't you give them your email?
Okay, it would be Susan, SUSAN, .steer, STEER, at com.state.oh.us.
Yeah, if it's a comprehensive letter of no objection and, hits all the bullet points that the board would be concerned about, we might not need to impose that condition. We may just be able to note it in the motion and the resolution, but let's see if we can get it really quick. Maybe just we're still a few minutes ahead of time. Why don't we just go off record for a second and see if
How about if we hear from Young in the meantime?
Well, we did.
Did he say there's no objection?
Yes.
Yes.
Okay, I'm sorry, I must have missed that.
And he also said that in his memo, but yes. Right. So, all right. So let's just go off the record for just a second and see if Mr. Schmidt can transmit that to Susan. And if not, we'll go back on the record and deal with it with a condition. Off the record, Tam.
Okay.
Hey, Susan,
Yes,
we don't need to be necessarily on the record. I think you were talking about those July dates. You want to let, I don't think Paul or Neil were on at that time.
yeah, hang on a second. I just received the email from
Oh,
Mr. Schmidt.
Okay.
Just a moment, I'll get that to you. You should receive it any minute.
Works for me.
It sort of reads as though a variance wouldn't be required, that the NFPA allows it. But, okay, letter's fine with, on Chip's end, Paul?
I'm fine
Yeah.
with it.
Do you want to go back on the record and then we'll just
Yeah.
paraphrase it real quick?
Tammy, back on the record.
Okay,
Okay, we're back on the record. We have Mr. Schmidt kindly forwarded a Chief Smith's correspondence that was direct, this is the State Fire Marshal directed to the chief. This is from the chief to the State Fire Marshal. Yes, and we have that in front of us now. And I'd ask the members of the board whether or not that would be sufficient on all four corners to obviate the need to impose a no objection condition.
Yes, I'm fine.
Neil,
I'm fine.
okay. Paul's fine.
Yeah,
And Brad?
just so that we can add this to our record, Mr. Chair, the letter from Chief Deathridge dated February 8th, 2021. So.
Right. And that will be obviously in the proceeding file. Brad, are you okay with the comfort level with the chief's letter?
I'm okay with it. I've got it muted. The people are working at my house. There's a lot of background noise.
Okay, all right. Okay,
Yeah,
well then,
okay with it.
the only condition then, I think, if we were to move forward with a variance would be the standard use condition.
Yeah, let me read through them, Mr. Chair.
Yep.
Variance is conditioned on the following. Number one, audible fire alarm notification devices are permitted to not be installed in animal use areas only. All other non-animal use areas shall have the required notification devices. And then number two, this variance is granted based on the use, construction, occupant load, project area, and level of activity identified on the approved construction documents, including the maintenance of all building systems and any conditions required herein.
Okay, any questions or comments with regard to those proposed conditions that will be imposed to a variance? You are muted.
The university's okay with that.
And the division?
Yes, that's fine.
Okay, I would entertain a motion then.
You want me to do it, Paul?
Yeah, sure.
Okay. Mr. Chair, for Board of Building Appeals, case number 21-0049. The appellant is Miami University for the premises Miami University Equestrian Arena at 4950 Oxford Trenton Road, Oxford, Ohio, 45056. The appellee is Jeffrey Eaton, supervisor, chief building official for the Division of Industrial Compliance in the state of Ohio, and adjudication order number 20200222353. I move to grant the variance subject to the conditions previously read into the record and noting the no objection of the fire official and the chief building official.
Very well. Is there a second?
Second.
All those in favor signify by saying aye.
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 Any opposed? Okay, gentlemen, the variance is granted to the University Equestrian Center on those conditions. Is there anything else to come before the board on that particular case? Okay, we stand adjourned on that case. It's 8:51. Susan, I know Ms. Harpster's on for the 9 o'clock case. Are we aware of anybody else?
I just received a call from Doug Simpson. He could not find his invite, so I just sent it again. Hopefully he will connect. And
All right.
and I believe Frank Rasinger is with him. Keith Brickner is present, and not sure. Amy, will Douglas, is it Ditto, be attending? Amy, are you there? Oh, I'm sorry, Mr. Simpson just arrived.
Right. Mr. Simpson, is Mr. Rasinger with you?
You need to unmute, Mr. Simpson. Unmute your computer or use your mouse and go over the microphone and just click on it.
We're a little early, but let's while we're standing on the record.
Okay. Oops, Amy, are you still there? She was here earlier. Maybe
Alright.
she stepped away. Her phone number's still here.
Okay, well, we don't have any new business other than the July dates, but
If somebody's on the phone though, they need to be able to type in *26, which will unmute you. Not everyone necessarily knows how to do that on their phone.
You know what? I think Amy dropped off. The other 419 number is Jessica, and she's present. So Amy must have dropped off the call. Let me see if I can get her back.
okay.
I don't see her phone number.
All right. We're still at 8:53. This case is until 9. We have no really new business to consider, so let's just go off the record for a second, Tammy.
Okay.
Hi, Amy.
Hi,
Yes.
I apologize. I was trying to get on the live event and apparently there's no audio, so I got back on the phone. I apologize.
Okay, as soon as the board returns, they'll get started. I believe everyone's here for your case.
Okay, thank you.
Thanks. Oh, Amy. Amy,
Yes.
do you
Yes.
expect Douglas Ditto to attend?
No, we had a meeting that we had to meet a customer out at a location, so we kind of divided up.
Okay, well then everyone's here. Okay,
Okay, thank you. Thank you.
Carl,
Yes.
everyone is here except I'm not sure if Paul and Neil are on.
Okay.
They're muted, so.
I am here, Susan. I just
Okay.
have it turned off so that it could say the live event is continuing, so.
Okay, Neil, are you available?
I'm here.
Maybe Neil. Oh, okay, everybody's ready then.
Okay, let's go on the record, Tammy.
Okay,
I'm gonna let the record reflect it's 8:57. We have a case set for 9 o'clock on our docket that I think we're in a position to proceed on a few minutes early. It's a Lima Allen County Building Authority case. It's case number 21-0053, and it deals with premises known as a new storage building located in Lima. And that jurisdiction's adjudication order number is noted on the docket. I see we have Mr. Simpson here on behalf of the appellant. Is Frank Rasinger on? Do you know? Mr. Simpson, you have not been able to unmute. Can you hear me? He has not been interactive. Oh, there you are, Mr. Simpson. Does that picture look frozen to you?
Yeah.
It might be tough to get through this. Mr. Simpson, your camera is frozen.
His audio might be frozen too, though.
Right, because he's got it unmuted.
We might have to have them call in.
Yep, let's go off record.
Vote him off the island.
Yep, off record again.
Susan, do you think you can reach out to Mr. Simpson via phone and have them call in? Because it doesn't look like their connection is working.
Yes, I will call him.
Okay, it looks like he got knocked out. That's Mr. Simpson I'm referring to.
They should be calling in any minute and they're gonna leave their computer muted.
Okay. All right, Mr. Simpson, you want to try to unmute?
They haven't called in yet on their phone.
He's to me like he's trying by way of his computer.
No, I asked him to call in. I provided him with the number, and Neil, he just got back. Okay, he got kicked out as well. I don't know what's going on. Here comes Frank Rasinger, I believe.
Well, I think he's with Mr. Simpson.
Mr. Simpson and Frank are together.
Right. I see.
Mr. Simpson,
Can you hear?
can you hear me?
Yes,
Okay, great.
Okay.
Ready
All
to
right.
go,
you
Neil's
can
back.
hear us all right now?
Yes, we
Yes.
can. Just keep your computer muted. You can watch.
Okay.
Do
Okay,
that.
we're gonna try to get through this. Let's go on the record again. It's case number 21-0053. Let's have an introduction of the parties, beginning first with Mr. Simpson and Mr. Raisinger. State your full name, spell your last name, and then the capacity by which you're here representing the appellant. We'll do the same thing with the building and fire official.
Douglas J. Simpson, Simpson. I'm a general contractor for Constructioneers Incorporated.
Okay, fair enough. And Mr. Raisinger?
Frank B. Raisinger, Razinger, the third, PE, engineer for the project.
Okay, Ms. Harpster?
Amy Harpster, building official, Harpster.
Okay, and who's appearing on behalf of fire today?
Keith Brickner, Brickner. I do the code enforcement for American Township Fire and Zoning.
Thank you. And is Mr. Ditto present? We didn't think so. Okay, Ms. Harpster, Inspector Brickner, Mr. Raisinger, Mr. Simpson, if you'd stand, raise your right hand. Tammy, would you administer an oath?
Yes. Raise your right hands. Do you solemnly swear that the information you're about to give in this hearing is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
All right, presumably, Mr. Raisinger, you're going to present, or Mr. Simpson?
Myself, Mr. Raisinger.
Okay, go ahead. You have the floor.
Okay, what we have is a pre-engineered metal building, 40 by 80. If you refer to drawing A1, I believe, is in your packet. We had presented this somewhere the end of 2019 in December for another site location. That project fell through and the building was not purchased. What we're seeking variance on is the building was designed and ordered in 2016. So it's prior to the new code for 2017. And basically we're seeking variance for the wind load conditions going from 90 miles an hour to 115 miles an hour. And that's, we've got letters from American Building that are in your packet, and also letters from American Township, and the letters also from Amy Harpster. And I do have her letter. I just emailed that to her today. The owner dropped it off from Mr. Gary Stankless, stating his understanding of what we're seeking this variance for. And that has been forwarded to Amy.
Okay, questions of Mr. Raisinger about members of the board?
Yes,
Yes, Mr. Chair, as the design engineer for this project, can you give us just a brief description of the required differences that would be required between the different wind speeds from the new codes? Like, what would you have to do to make this old building?
Well, one of the letters from American Building, it's actually the same letter we presented in the first hearing, stating the cost of additional design, somewhere around $4,800 to do that, with a long lead time at that time. Obviously, we'll have a longer lead time nowadays because all the pre-engineered building companies have a severe backlog, and they're not even delivering buildings till at least Thanksgiving or Christmas time this year. They'd have to be installing additional bracing based on their reevaluation of that 40 by 80 building from the 2016 design package. If you find that letter in your package, that's what would be involved to upgrade the design to the 115 mile an hour wind speed.
Mr. Raisinger, is
Yeah.
this the same building that was approved in 2019?
Yes, it's the exact same building. The site is the only difference. The use of the building will still be S1 storage and strictly enforced as S1 storage only. The previous owner did not purchase the building, so the contractor still had the building available. He found a new buyer in Mr. Stankless. So we're proceeding with this variance, assuming the variance is given. He can go ahead with the purchase and move ahead with construction of this building.
When you say it's the same building, are we talking about the same specs, same size?
Yes, 40 by 80. The building on drawing A1 has a addition of another bay to it, but that's going to be designed separately based on 2017 code requirements and the 115 mile an hour wind speed. This is the base building of 40 by 80 only, shown as a shaded area on drawing A1.
Mr. Chair, I just have to say, I don't have any drawings nor any letters from and the manufacturer in our packet. I don't know if I'm missing something.
No, I don't either, though. Susan, what do you have? And
I'm sorry, which letter? I believe everything was made available that I received.
Yeah.
What letter?
Mr. Raisinger has talked a couple times about a letter from the metal building manufacturer and some drawings, neither of which I have in my packet.
well, and then Mr. Raisinger, what letter was it that you sent Ms. Harpster last night or this morning?
She requested a letter signed by the owner
Okay,
stating his understanding of what this variance is in
Okay.
reference to.
And I am forwarding that letter now. I just received it from Amy Harpster.
okay, so we can
Okay.
take a
From the
look at
owner.
that.
Yeah, the building letter I'm referring to should be at the end of the packet with the drawings. The
There are
American
no
Building.
letter,
Shop
no
Terminal.
letter, and no drawings in our packet.
Oh, look at
Correct.
the file that's labeled compressed.
Say that
Yeah, I
again.
sent those to Susan last week.
I will double check my emails, but I believe everything that the board has is what I have in front of me as well. So I will check my emails. to
Do
see
you
if
have any drawings there, Susan?
I'm checking my emails. They came from you, Frank?
Well,
Yes.
I don't know if this will work with with the building department or whether you're equipped, Mr. Raisinger, there and with Mr. Simpson to be able to put anything on the screen, because you're calling in now, right?
Yeah, we're calling in now. We keep
And
dropping
Ms.
the video
Harpster,
feed.
And Ms. Harpster, are you a call-in?
I am, Mr. Chair.
So, Mr. Raisinger, what exactly is the reason they're purchasing a building that is not code compliant? What is the hardship here? I'm not understanding that.
Well, the contractors had this building available for purchase, and he had it sold to the previous buyer, and that project fell through. So he's had it essentially up for sale as a strictly S1 storage type building if not an S2. And it was approached by a potential buyer. So he's interested in purchasing this steel building package. And then we'll add that small bay to it on the front end. And then he's going to use it for S1 storage. Because he'd like to have the building erected prior to this fall. And ordering buildings now, you're looking at Thanksgiving, Christmas time delivery if you order now. This building is available and can be up as soon as concrete is ready.
I have a question. This is Brad Smith. You're the contractor, or you own the building at the current time? Is that correct, Mr. Simpson?
Yes, I do.
Okay, and then Gary Stankus is going to buy it, is that right?
Correct.
And you're the one, Mr. Stankus is not the one filing the appeal, or who's filing the appeal?
I think it's Mr. Simpson, but I think that's why Ms. Harpster wanted the letter from Stankless. Is that correct, Amy?
Yes,
So-
Mr. Chair, that is correct.
So this is benefiting the person who owns the building who's trying to sell it, not the guy who's buying it.
Well, it's benefiting both of us. This is Mr. Raisinger speaking. The contractor can get his building sold. The purchaser, Mr. Stankless, can get the building purchased. And since it's already available, he can get it erected as soon as foundations are made available.
I guess I'd follow up on Neil's question. What's the hardship for the owner? I can see the hardship for you. You've got this old building that you're
Right.
trying to sell, and it doesn't meet the code, and you don't want to spend any money to make it meet the code. So I can see that's a benefit for you, but I'm not sure the guy who's really buying it, he should just go buy a building that, that meets the code. Then he has a new building that meets the code.
Cost is significantly higher from 2016 to present. Building prices have gone up 50% since November of last year. And this building has probably increased even more. So it's a bargain. That's why he approached me. He needs a building. He wants a building. He's going to save him several thousands of dollars by going with this building. And the only difference is the wind load component.
Any other questions of any of the parties? Okay, let's hear from our CBO, Ms. Harpster.
Thank you, Mr. Chair. Certainly the building department I provided the letter and we do not object and are supportive of the variance. And I, as stated in there, I did want a letter from the agent who represents the entity, Great Sites Lima LLC, to make sure that they understand that this isn't built to the current code. And, potentially the reason codes change, as we all know, is because in this case, we realized, hey, in Ohio, we have a lot higher wind gusts than we had before, and we need to reflect that in the code. So it going from the 90 3-second gust, 90 mile per hour 3-second gust to the 115 mile per hour 3-second gust was important enough to put it in the code. So I did not take this lightly. I did want to make sure that the agent for this entity understands the difference. Thank you, Mr. Chair.
Okay, questions of Ms. Harpster?
Yeah, I have a question, Ms. Harpster. So it's okay to sell for somebody to build a building that doesn't meet the building code as long as they understand it doesn't meet the code. Is that the position you're taking?
No, well, I'm supportive of anything, conditions that the board may put in there. as far as the conditions, my question has always been, what can we do to reinforce the building or make adjustments to make it code compliant? And my understanding from talking with Frank, that was where the cost exceeded potentially the value of the project. Does that explain it, or?
No, I mean, he was kind of vague. He said that it would cost $4,800 to analyze it, and he didn't want to spend that amount of money.
So, Mr. Chair, if I may, that would be, I'd like to defer that to question possibly, if Mr. Chair deems appropriate, to Mr. Frank Raisinger, the design professional.
Sure.
Yeah, this is Mr. Raisinger. The 4,800 is stated or quoted to Mr. Simpson from American Buildings. That is for analyzing the building and redesigning the building, and that's their engineering cost with the 4,800. Any hardware, bracing, angles, additional steel package to meet that $4,800 design would be additional cost, and they don't know what that amount would be. It could be another $6,000–7,000, if not more, based on what they come up with for the additional bracing. More than likely, they would have additional angle bracing on some of the roof purlins to beef that up, and maybe some plates on the rigid frames. We don't know what they would come up with because they're responsible for that. But the 4,800 is only for American Buildings engineering, and then it would be additional cost to implement that engineering, I guess, upgrade to the building to meet 115 miles an hour. So it could be in the neighborhood of $10,000 to $12,000 altogether.
Or it could be $20 for some upgraded bolts. We don't know.
Yeah, we don't know, but
Right,
at the
so-
time, right now, we'd be looking at those members. We don't even know when those would be able to be delivered. So he could put the building up, it's not even able to be inspected until all that stuff is available. But we don't know what that is.
Yeah, we did in December of 19 by a 4-to-1 vote, voted in favor of the variance. I will say, Brad, you voted nay with respect to the building.
And I would say I haven't changed my mind either.
Mr. Raisinger, I have a question. Is this proposed building, is it located anywhere near other facilities or other buildings?
It's within 500 feet of an existing building, but that meets our restroom requirements. We're not installing restrooms or plumbing in this building. Yeah.
What is the actual distance? What's the closest it is to an existing building?
Oh, it's at least 200 feet away.
Okay, because I saw in the 2019, when the original one that we did approve was 200 feet away from an existing building. I was just wondering.
That one was probably farther away from any neighboring buildings. This one's a little bit closer, but we've got at least 200 feet.
Okay.
Mr. Chair,
Yes. Go ahead.
if I may, this is Amy. From the existing building, I'm looking at the site plan, and I don't know if this perhaps answers part of the question. It looks like it's 48 feet and 10 inches from the existing building.
Oh, wow.
No.
And is this building occupied?
I don't know what she's looking at.
Is the building occupied? No, it's
The
not occupied.
The existing building.
Oh, the existing building is occupied.
Neil, from the site plan, the existing building is to the northwest. So if there was going to be a wind gust, it would be coming from that direction, opposite of where the house is, if that's what you're getting to. If this thing falls down, what else is it going to damage? There's nothing to the east, southeast, or northeast of this new building.
And that's exactly what I was getting to. Thanks.
Mr. Brickner, do you want to weigh in here, please?
Yes, a short history on where we came with this building. Initially, this building was designed for another business in an M1 district to the south of where they're proposing it to be located. That structure did not meet the size requirements for the owner at that time, so they redesigned and brought another building in. This building was never erected. It was left on site off to the side. It sat that way from 2016 up until this past year, in which case the business that's looking at building it now has already done one addition to their existing structure, and they have grown enough to require this second building. Way we approached it and what we was looking at was, if this building had originally been erected on the property 200 yards to the south, according to the recommendations of the manufacturer and the local building code, we would be dealing with this structure in this state as it would appear. So as long as this structure being erected on the new property, according to the manufacturer's recommendations, and anything that the board may also recommend, like the snow load and other structures or areas of this building has been met. So the only thing that has been met is the 15-mile-an-hour wind load. It's our approach that if it had been originally constructed or erected on the property where it sits, would have sat, we would be dealing with the same structure at that time as we're looking at it today on the new property.
Questions of Mr. Brickner?
Yeah, if you had a building that was manufactured in 1970, but it hadn't been constructed yet, and now that you wanted to construct it, you'd have the same argument. If it had been constructed and erected in 1970, you know, you'd be dealing with the same building. I mean, I guess I don't agree with that argument either.
Right, and what you're looking at is the 30-year time period versus a 5-year time period in customs as far as building regulations coming up to where they are at this point. Now, naturally, if it was a 30-year-old proposed building, we would have to take a second look at that because, we would be looking at different features of the area. And that's another thing to look at is the area where this is at. It's in an M1 district with the other properties or buildings that are occupied by other businesses are several hundred yards away in any direction.
So what keeps somebody from building another building closer in the future? I mean, as if that's a requirement for approval. But, you know, I mean, what's to keep somebody from building something that's occupied nearby? I guess we're saying that the building falls apart or flies apart, it's going to hit another building. And that's what we're worried about. I mean, seems like we're stretching the argument here.
Well, if I could interject, Miss Harvester, how, if this building were to be erected on its original site that it was intended for, in terms of your building permit, how long does an owner have to erect the building from the date that the permit is issued based on our adjudication? 2 years, 18 months?
So, Mr. Chair, if I may, first and foremost, the OBC, once plans are approved, that's your license to build, and they have a year. They can request an extension, but they have a year to build it. That their plans are approved for that year. a local codified ordinance which recognizes permits, they have to start the permit within the 6-month time period or request an extension.
And how long of an extension can an owner get? Up to another year?
Potentially, it goes in increments of 6 months, consistent with the OBC, where it talks about extending. They have to request it before 10 days prior to the expiration.
Okay.
And then they can potentially get 2 extensions maximum, but they're in increments of 6 months.
So thank you. I guess my point to my fellow board members is if they weren't changing the site of this building, they could still be sitting on it and not having constructed it yet. So, I mean, I guess ultimately I'm in favor of the variance only because it's the same building, but it's 200 yards farther away. I mean, and we could be in the same boat.
The only thing is,
the original location.
my
Now,
opinion.
this is, excuse me,
Hold on, Mr. Raising. My opinion, Chip, is they have a structure 48 feet away from it, where I believe in the prior variance, the nearest structure was 200 yards away. So you're talking quite a bit difference. I mean,
Yeah, well, let's drill down on that. What is the change of circumstance, or how do the facts change in terms of site here? I'm confused.
can I interject here? This is Mr.
Please.
Raisinger.
Please.
I looked at the drawing. I didn't have that in front of me, but the 48 feet is correct, building to building on a straight line measurement. The buildings are kind of skewed corner to corner. The clearance between the buildings is 56'3" roughly. The 200-foot was door to door entrance to access the restroom area in the other building. We do have 630 feet behind the whole property line on the south side is 667 feet roughly. 260 feet from the right of way, and then to this proposed building. So we've got another 3. We could move the building further to the east to separate these 2 buildings if that needs to be a condition applied to this variance. Right now, he wanted to locate the building where the end of the paved area is to minimize access drive to get to the building. But we can move the building, like I said, to the east and increase that 48 or the 56 feet on angle corner to corner if required. So we got a little more buffer in between the existing building and this proposed building. If that helps clarify some things.
Does that move the needle for you, Neil?
you know, I'm not sure. I have an issue similar to Brad's, where why don't they just buy a building that's, complies with the building code? Unfortunately, I'm not very well versed in wind loads and how they're calculated, and, actually how important the calculations are, why they changed the building code. So I'm still up in the air if that would move that for me. I'd rather hear from maybe some of my colleagues that are a little more knowledgeable in this part of the code or the structure, or for the structure.
Well, I think Amy made a good case for it. She said in her remarks that, they had to upgrade the code because they knew that the wind is, through documentation, that it's, it's a lot higher than they thought in the past. I mean, I think she made a good case for that. The other thing is, let me ask Mr. Raisinger, what's the total cost of the project here?
I don't know, 150,000.
Roughly 150,000.
Okay. And right now you don't know, there is no, other than it's going to cost $4,800 to analyze it so you can figure out what you need to do. You don't know.
Yeah, we
You know,
don't
maybe-
know, but
Maybe it's
I think, we've been-
$10,000. You know,
it probably $10,000 roughly, and
Okay.
if we move the building, driveway costs for that,
no, I'm just
but,
talking about the building, just the building. So
Yeah.
it's
just the building.
probably maybe 10% of the cost to do it right. I mean, I don't see the hardship other than, it's
Mhm.
going to cost some money to do it right. If the owner already owned this and it was sitting on his property, he just, to use, I think Chip's analogy, or that he had it and it hadn't been erected for some reason, and now he wants to erect it. I think it's a different case, but the guy hasn't even bought the building yet. We're dealing with the supplier here who's trying to sell this building. And so I think it's, if this, like I said, if this was the owner that already had it and for some reason hadn't erected it, that's a different case. I just don't see the hardship,
In my opinion, Brad, I think the hardship's the time frame for them.
Yes, it is. We'd be waiting on American Building for,
And the cost.
and well, then additional cost as well, so, and also delivery, we'd be waiting on them to redesign it, evaluate the cost, and if the owner proceeded with that, what is the time frame of, delivering these parts for them? Because that would have to come from American Building product, not just off the shelf at any steel fab location. And then they would probably send a representative to evaluate that it was erected per that design, correct?
So, Mr. Raisinger, I'm going to ask a question, and I don't want a dollar amount, but I understand what's going on with the marketplace and building materials and whatnot. Is your client charging more for this structure now than what they did in 2019?
No,
No.
it's probably $20,000 less, which is the reason Mr. Stank was as interested in buying the building. It's a tremendous bargain for him, and we can take it off our hands. It's a brand new building, never been erected. If it had been built in 2016, it would have met all the codes. So the comment about whether it's going to blow down or not, what about all the buildings that are built under the 2011 code? They're not going to blow down.
Well,
Is this-
Mr. Chair, let me throw in, and maybe this will get us to somewhere where we need to go, depending on what direction you want to go. I think I would be supportive of a variance. I do see that, yeah, there's not a hardship. I think spending, $5,000 to find out what they need to do is probably something that should be done so that they can at least know the answer to that. But that being said, if I'm driving down 71 to get to Columbus for our next hearing, and I'm going 90 or I'm going 115, either way, I'm gonna get in trouble. So they're both really fast. They're both very powerful. The little difference between the two, I don't think is really going to be that big of a difference from my point of view. So I would be supportive of a variance for this.
My recommendation, if you're going to get in trouble either way, you ought to go 115.
That's right.
I'm on board with that thought process in adjunct to what Chip said earlier, unless he has moved off that position.
No, I have not. I'm still in favor of the variance with the use condition.
Well, Mr. Chair, I'm not in favor. I don't see the hardship. The code changed for a reason. To comment on someone's prior comment, I mean, back in the 1970s, there were no fire suppression codes and buildings burned down. Now there's suppression codes, and that eliminates a lot of that problem. So the code changes for a certain reason due to past history. So for that reason, I don't see the hardship, except for maybe the time frame. So I am not in favor of it.
Okay, and Brad put you in that category?
Yeah, I voted against it before, and I don't see the hardship, like I explained, if the owner had the building and it was sitting there, but that's not the case. This is a building company that's trying to sell this product now that's, doesn't meet the code. And, I guess to use a phrase, I mean, they're asking us to change the law because they've got this building they're trying to get rid of, and they're not willing to spend a few bucks to even figure out what it needs to do to make it right. And so I think that's the bottom line in here. And, I'm not willing to change the code or, give them a variance for that.
Okay, understood. That's why we deliberate. Paul, do you need time?
No, let me just ask you and Chip if, we could throw in the variance to have them find out what's required to repair it. So at least that the person who's buying the building knows what that is, if that.
But my thought on that is, I don't know that we should be meddling in the transactional affairs of the parties.
Yeah, but here's what I would say. I applaud Ms. Harpster requesting that the owner provide her with a letter so that they know what they're getting, right? We have the person who owns the building right now, the contractor, who's selling, this building to somebody else. I think it's incumbent, as Ms. Harpster recognized, that person, they are getting a building and they need to know that it doesn't meet the code. So I think that's something that is important to know. Again, whether or not we would think that it's important also for them to know what it would take to fix it. They may say, hey, you know what? It's only going to cost me another couple $1,000s to put some bracing on. I want to do it. And that way, again, Mr. Razinger's an engineer. He knows, he's the person that's responsible because these are his drawings. Those are the kind of things that, again, might be worthwhile doing.
Are you suggesting then that you undertake the engineering analysis and submit it to the building department?
Yeah.
So that it's in the file?
That's what I'm thinking. And that way, again, the end user is aware and of what would need to be done to the building to bring it into conformance. I don't know. It's kind of along the same lines as Ms. Harpster wanting to make sure that the owner knows what he's getting, I guess.
But you're asking a layperson to make that decision. They hand them an analysis of it and says, well, it needs this and it's going to cost you $10,000. What do you want to do? And they'll say, well, I don't know. Is it safe or not? And
have you ever bought a used car?
I think it's a different
I
situation.
buy used cars all of the time, right? And the thing is, it's not brand new. So I know there's stuff that's going to have to fix on it. I'd rather know what that stuff is ahead of time so that I can figure out down the time. That's the way that I'm looking at it.
Yeah,
Again,
but in this case, they don't have to fix it. It's going to be optional.
right.
Yeah.
Just
right.
like that ding in the side of the door.
I just want to add one other thing to my comment on voting, not in favor of the variances. The purchase price is $20,000 cheaper than it was the first time, approximately. So I don't know why they don't want to bring this building up to compliance, or at least make every attempt to do so.
Okay. But Chip, I guess Paul's thought process is directed to you and I. I'm not married to that idea, but I wouldn't object to it. What are your thoughts?
So Paul, you're suggesting that as one of the conditions that they still would be required to provide the engineering analysis that advises the new owner what has to be done to bring it up to code?
I think so, and have that submitted to the building department so that Ms. Harpster has it on file. Again, it's, I'm not super sold on this, but again, it's falling along the lines of which I think is a good idea for Ms. Harpster, is making sure that the new owner knows what they're getting.
I would support that. I think any information is good information.
Okay, I won't stand in the way of that. Let's give you a moment to craft that language. We'll vet that, Mr. Raisinger and Mr. Simpson and Ms. Harpster, Mr. Brickner, see where we are. Maybe it'll change Neil or Brad's mind. We'll go off the record, Tammy.
Okay,
And I'm going to step away for just a minute.
How long would it take for American to look at that? Thing is, Gary's not gonna pay a dime over 40,000. And I don't have any profit in it, so I would spend $5,000 for an initial, for an evaluation. This doesn't make sense for me either. It's less than 100 pounds modification, and it's on the frames only.
Okay, Mr. Chair, I am ready to read these conditions.
Okay, Tammy, back on the record, please.
okay,
Variances granted based on the following. Number one, the engineer of record shall have American Buildings perform the design analysis required to bring the structure into code compliance for wind loading and submit those calculations and drawings to the building official before a certificate of occupancy is issued. Number two, this variance is granted based on the use, construction, occupant load, building area and level of activity identified on the approved construction documents, including the maintenance of all building systems and any conditions required herein. That's it.
Okay, Mr. Raisinger, you want to weigh in on those proposed conditions? Or primarily the proposed condition number 1? Oh, you're muted. I think Susan muted you because you were discussing things. Susan?
Yes, I did. Just hit *6 on your phone and that should unmute it.
Okay, can you hear me now?
Okay, yep, we can.
Yeah, on the item 1 there, the required ABC or American Building Corporation analysis, you're stating that that would want to be supplied to Amy Harpster's office before certificate of occupancy is granted, as opposed to issuing the building permit. So they could be working on this. A lot of it's going to be contingent on the time frame for American to be able to even get this into their mix to look at that. And they've got
here's what I would say. If we want to modify that condition, Mr. Raisinger, you are an engineer and probably capable of doing that engineering analysis yourself. If you wanted to
do the question, does it need to be performed by American Building? So,
well, and then you'd have to ask yourself, do you want to take responsibility for that, which it doesn't seem like you're willing to do in this particular case? That you want to make sure that the building does that analysis.
We can look at that because I'll be stamping the additional bay added onto the end of this, because the American Buildings is only 40 by 80. And during the break there, we were discussing additional X-braced bay. So we would double up on the X-bracing on the existing 40 by 80 building. But we'd have to see what that amounts to overall doing that.
You could do, why couldn't we do the engineering analysis conducted by the manufacturer and or a licensed PE?
That would work.
Well,
and then then also the time frame of, can they issue foundation partial so they can get going with this after we get approval from the potential buyer, Mr. Stankless, to go ahead with this additional engineering, regardless of who does the work. So that if the engineering calculations are turned into Allen County before issuing certificate of occupancy, they can be at least moving on the project, which is his main goal, to get the thing going, and also his intent to buy this building, which is already available, that we can do that and get it taken care of. And I'd probably be analyzing that along with the additional bay, if that works as far as the conditions go.
all right, let me move the dialogue for a second. Ms. Harpster, what are your thoughts on the condition that has been proposed and read, and then the conversation we had afterwards?
Thank you, Mr. Chair. So if I'm understanding correctly, the condition, so we're going to be aware of and make the owner aware of what it would take to bring the 80 by 20 into compliance with the wind, the 115 mile per hour, 3-second gust.
Notwithstanding the fact, though, that the variance will be granted under this pathway. Yes.
Right, and it kind of sounds like Frank may be kind of commingling right at the point of attachment where the two buildings come together. I just want to make sure that we keep them separate. I mean, they're together, but separate, so it doesn't get interfered in the approval process. I think we're okay with that. And I can provide that. I would also want it provided to the owner of record or the agent for, not just the building department. And we normally talk closely with the fire department, so I can provide that to the fire department and/or, so there's 3 people I want to know about it: myself, the fire official, and the owner or agent for.
Yeah. Mr. Brickner, you want to weigh in here on behalf of fire as it relates to the condition?
Yes, I agree with Amy. This is Keith Brickner. Yes, I agree with Amy on the recommendations, especially with the knowledge of everybody that knows what's going on. But also in listening to Frank as far as some of the additional reinforcement that would be going on, we're halfway there to possibly meeting some of that wind load requirement or upgrade. So in taking that into account, is the new addition going to be bringing the other side into compliance as this proceeds forwards? That's all I have.
Okay.
It is possible, and we'll know what needs to be done. That's the good thing at the end of this. Here's what I would recommend then, Mr. Chair, that condition number 1 be revised to read as: the engineer of record shall prepare a design analysis required to bring the structure into code compliance for wind loading and submit those calculations and drawings to the building official, fire official, and record owner before a certificate of occupancy is issued.
Okay, I like that. Mr. Raisinger, are you comfortable with that?
Yeah, that works.
Okay. Ms. Harpster
Yes, thank you, Mr. Chair.
and Mr. Brickner.
Yes.
Okay, I think we're to a point where we have a motion.
Yes, Mr. Chair, for Board of Building Appeals, case number 21-0053. The appellant is Great Sites Lima LLC for the premises new storage building at 2280 Beatty Road, Lima, Ohio 45807. The appellee is Amy Harpster, building official for the Lima Allen County Building Department, and adjudication order number 2021-001838. I move to grant the variance subject to the conditions previously read into the record, and noting the no objection of the building and fire officials.
Okay, motion's been made. Is there a second?
Second.
Okay, all those in favor signify by saying aye.
Aye.
Those that are opposed?
Nay.
Okay, since we did that audibly, that was Brad and Paul and Carl in favor of the variance as made by the or in favor of the motion, and that was Neil and Brad that voted nay. Okay, Mr. Raisinger, Mr. Simpson, Ms. Harpster, Mr. Brickner, thank you. The variance is granted narrowly on those 2 conditions. Is there anything else to come before the board at this point in time on this case?
That should take care of it. Thank you.
Okay, all right. Hearing none, we stand adjourned as it relates to that case. Paul, do you want to take a short break before we call our Mommy fire case? Since you have
I am okay. I'm still working my way through my coffee.
Okay, well, I think we have the parties present for the next case. We'll find out. Tammy, you okay to proceed?
Yes, I am. Go ahead.
Okay, very good. Okay, we're going to call the last active case on our docket today. As I indicated, it's fire case. It's Mommy Fire, and it's case number 21-0047, and it deals with the premises known as the Mommy Assembly and Stamping Facility located in that jurisdiction. Let's have an introduction of the parties, beginning with counsel for the appellant. We'll do the same thing, and then you can actually go ahead and introduce the client with whom you're appearing with. We'll do the same thing with counsel for fire. They can do the same thing. Just state your full name, spell your last name, please.
Hi, can you hear me?
Yes.
Okay, my name is Jessica Worley, W-O-R-L-E-Y, on behalf of Mommy Assembly and Stamping. And we should have Mr. Lenny Schramm on the line as well.
Okay, Mr. Schramm, are you there?
Yes, sir.
Okay, very good. Mr. Dusick?
This is David Busick, B-U-S-I-C-K. I'm the law director for the city of Maumee, and I have Assistant Chief Dussault with me as well.
Okay, thank you very much. Okay, if Mr. Schramm and the Assistant Chief would stand, raise your right hand. Tammy, would you administer the oath, please?
Do you solemnly swear the information you are about to give in this hearing is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, very good. All right, Ms. Worley, do you want to proceed?
Yes.
Go ahead.
So, as we, spelled out a little more fully in our April 19th correspondence, Mommy Assembly and Stamping is appealing the violations, the penalties, the 30-day time frame to comply, and the additional $1,000 per day penalty for violations not cured after those 30 days. And additionally, is requesting 9 months to complete repairs. We submitted a packet that contained several purchase orders and service requests that are also more fully identified in the citation and order that we included in our packet. So if you look at that citation and order copy we included, Mr. Schramm has spelled out which service requests and purchase orders relate to each violation to show that the work is being either worked on, completed, or is still pending. They've completed some of the work and have been in contact throughout the process with Fire Chief Lance Tunison and Deputy Fire Chief Jim Dussault, just keeping them informed of the status of these repairs. Unfortunately, they can't do the repairs themselves, and so they're kind of at the mercy here of Johnson Controls on when these can be completed.
Okay, so that really was in the form of remarks by council. You're not necessarily inclined to put Mr. Schramm on, correct, at this point?
If Mr. Schramm has anything he feels is important to add or any specific questions directed to him on the status of these repairs, then I'm perfectly okay as long as Mr. Schramm is comfortable answering those questions.
Excuse me, Chairman.
Yes.
Neil Gearing has dropped off. He just called me. If we could pause for a moment. He did not, he was unable to hear the testimony from the.
I just got back on.
There he's back.
Yeah, so I missed the entire beginning of the testimony.
It wasn't testimony, it was Ms. Worley's comments, but can I indulge you, Ms. Worley, to re-summarize what you told the rest of the board members, please?
Yes. So I'll start off at the top of what we're appealing here, and it's the violations, the penalties, the 30-day time frame to correct all deficiencies, and then the additional $1,000 per day penalty for violations not cured within that time frame. And in the packet we submitted, we included a copy of the citation and order that includes markings along the sides of each violation that associated to included purchase orders and service requests, along with statuses of whether or not the violation is being worked on or is completed. And so again, in our packet, we also have those service orders or service requests and purchase orders to show the work is being worked on, is being initiated by Mommy Assembly and Stamping. Unfortunately, though, they're at the mercy of Johnson Controls on when this can be completed.
Hey, Carl, I
Yes.
have one more. I have one more issue. Johnson Controls is a signatory contractor of mine. I don't know if that's going to make a difference. We do not have jurisdiction in the Maumee area.
Well, I'll ask Ms. Worley and Ms. Busick if they think that taints you such that you should recuse yourself. You don't believe it has any, that it would influence you in any way, correct?
I don't know if any of my members actually would have conducted the inspection because I didn't see any member's signature on there. but we have 80-some contractor signatories, so I don't believe it would influence me one way or the other.
Ms. Worley, Ms. Busick, any comments in that regard?
On behalf of the city of Maumee, we would waive. I have no issue with that.
We would also waive, given, you know, the opinion that it wouldn't influence any decisions there, we would waive as well.
Okay. Appreciate that. Okay. Let's hear from the city first, and then we'll, you know, and if it's just going to be remarks by council at that point in time, I'll have, I'll open it up for questions of council by members of the board. If the assistant chief Dusso testifies, Ms. Worley will have an opportunity to engage in some cross-examination before we ask questions of the chief. So, council.
I believe if I'm speaking on behalf of the city, we're just looking for compliance. Obviously, the city is not in the habit of writing citations. Having talked to Chief Dusso, this is the first one he's done. He's been here for quite a while. This is beyond what we're used to dealing with, quite frankly. We usually have pretty good control over the fire systems in the city, and this is beyond the pale. So we would just ask for some fairly strict guidelines be imposed.
Okay, so I'm not sure I understand exactly what that means, but let me ask my colleagues, what are your thoughts moving forward here, based on what you've heard thus far?
Here's what I would say, Mr. Chair. I probably need somebody to give me some indication of when we think things are going to be back in order. I understand stuff is in process, and we don't have a definitive, but a general. So maybe somebody, and it might be Neil, that can say, hey, given the violations that are there and the work that they have to do, it's going to take, you know, another 2 months. The request for another 6 months, I think, is too much. So I would be in favor of voting to uphold the citation, assess a one-time civil penalty of $24,000 plus an additional $8,000 per month until the violations are abated, all of which shall be waived if violations are completed by whatever that time period is, which is reasonable.
So if there was compliance, the financial penalties would be waived.
Correct.
Gotcha. Let me first ask the city, is that something that you'd be amenable to?
That's almost exactly, I didn't have a dollar figure attached, but that's almost exactly time frame wise what we had contemplated.
Okay, Ms. Worley, do you want to comment on that before we get ahead of ourselves here?
So I will say that I haven't received an indication of when these repairs will be done. I know Mr. Schramm's on the line. Lenny, have you received any word from Johnson Controls on an expected date for these repairs to be done?
No, the only thing that I was told was that parts are, and some of the material are on back order, and they're at the mercy of when they can get the material and parts. And they indicated to me some of the problem with that was because of all the problems they had in Texas with the freezing, that a lot of parts were taken for that.
Okay.
So, Carl, can I say something here?
Please.
I am aware that in our areas, parts are a huge problem for all of our contractors. So I know Paul recommended the 2-month time frame. I personally don't think that's a sufficient amount of time. I don't know if the city would be agreeable to maybe a 3 to 4 month time frame.
Teeing that up to you, Mr. Busick.
I think, yeah, we could look at 3 months, and if it's still, if the parts aren't there, they're not there. I mean, you have to be realistic about that. I mean, we can't make them make a part. So I think does that, when we conclude here today, and if we
upheld the citation, issued the financial sanctions that hopefully go away, and impose a 90-day window, if you will. If there are issues with parts on the 91st day, I assume your office will work with Ms. Worley?
Yes, we could do that.
Okay. Chip, your thoughts?
I honestly would go longer.
I would too.
I mean, I don't know that, I don't know the sprinkler industry. I mean, but I believe Neil when he say parts are an issue. I mean, granted, I don't want to put this out forever, but I also don't want the appellant in a situation where they're, I don't know. I was looking at 6 months.
Here's my concern, Mr. Chair. How big is this facility? How many hundreds thousands of square feet is this?
Approximately 800,000.
Yeah, it's 800,000 square feet. How many people work there?
Right now, we're just under 200.
Yeah,
About
so
170.
And
so I mean,
yeah.
that's 800,000 square feet and 200 people who don't have a sprinkler system protecting them in manufacturing facility. So, you know, 6 months to me is too long.
May I say something?
Sure, please.
The system actually works. You know, it's just a problem with some of the inspections haven't been done
Right.
properly. We have a dry system over there that is up and functional. We have pumps, and that was all in the report. We have 2 fire pumps that have been tested annually. They work. There's just some internal parts of the sprinkler system that need to be corrected, and they're doing that as best they can. As the deputy chief, I've been in contact with him and sent him all the paperwork as they're moving along with this, and they've corrected quite a bit of the issues so far.
Brad, let's hear from you.
Yeah, I mean, actually looking at his list, a lot of these things have to do with complete 5-year internal pipe inspection.
Yeah.
I mean, that shouldn't take, and I'm wondering what parts they are. Maybe they're post indicator valves or something, I bet. You know, I agree with Neil and Chip that we should give them as much time. They wanted 9 months. I mean, that to me actually didn't seem that unreasonable. But another thing is, I think you know, you might think about prorating the fine, the citation costs, because if they were left with they didn't get some caps for their fire department valves or whatever those are. I mean, you would assess of the whole thing for one item. I mean, maybe the city will prorate it or something, but that would seem like a pretty severe penalty. So I'd be more on the liberal side, giving them more time.
Let me take care of some housekeeping here real quick though, but you know, maybe Chief Jusso has to testify for a minute, but Ms. Worley, do you stipulate that the citation was received and that it was served on the appropriate party?
Yes, we received citation and order 3773 in our office. Attorney David Cole of our office is the statutory agent for Maumee Assembly and Stamping.
Okay, okay. We can dispense with that issue. All right, so it looks to me like we are unanimous in upholding the citation. I think maybe Brad put sliced it a bit, but I think we're in favor of generally the financial sanctions that were proposed by Paul at the outset. And now it comes down to a matter of time for compliance before those sanctions are abated. I know the city is now maybe reluctantly agreed to 3 months. We've got 3 board members that have been vocal that may not be enough. And we have 1 board member that would like to keep the timeline constrained. So we're going to get to a point here where I think we're going to have to make a determination. Chip, you want to throw out a resolution, or Neil, that you think might?
I would go to 120 days, Carl.
Hey, Carl, can we hear from the fire official in his thoughts on this?
Yeah, Mr. Busick, is that okay?
Absolutely.
Okay, Chief, you're under oath.
Okay. Are you?
Yeah, I thought you were going to ask him a question. I thought.
Yeah, what would be a reasonable time frame for you? Because honestly, I would be closer to the 4-month period. I believe 6 might be a little extensive.
I personally would say I would be okay with that. And I will agree, well, as Lenny stated, they have been making progress since the citation was filed. So as long as this forward progression is continuing, that's a good thing. You know, parts are parts, like you guys said. We can't control the economy and what's going on with materials out there. So I'm not opposed to, I guess, what are we looking at now? 120 days? Is that what the last I heard?
Yeah.
Well, yeah, Mr. Began has moved off the 60 and would be agreeable to 120.
And I would too, Carl.
Okay. Chip?
Yeah, I'm okay with 120 days.
Okay, well, Brad?
Yeah,
Okay,
yes.
okay. Ms. Worley, any comment here before we take this to a deliberative vote?
So just so I have a clarification here. So right now, the suggestion is 120 days to be fully in compliance. And if they are in compliance, there's no financial sanctions. But if they're out of compliance, even by 1 item, they get the full financial sanctions assessed.
If the city attempts to collect on it or enforce it, yes.
And that's why I asked counsel for the city whether or not the city would be working with you if you got up to the 11th hour. And there were circumstances beyond your control that prevented compliance. Otherwise, you acted, assuming your client acted in good faith.
Okay.
Okay. Paul, do you want to take a stab at this?
Yeah, can you give me just one second here, Mr. Chair?
Yes, absolutely.
Thanks.
Off the record for a minute, Tammy.
All right, let's give it a shot, Mr. Chair.
Okay, back on the record, please, Tammy.
Okay,
Here's the wording that I would put into a motion. I move to uphold the citation, assess a one-time civil penalty of $24,000 plus an additional $1,000 per month for each outstanding violation until all violations are corrected. In the event that the violations are corrected within 120 days of this order, the entire civil penalty shall be waived.
Okay, Ms. Worley, any comment on that proposed condition that would be part of the citation upholding?
No.
Okay, and Mr. Busick?
No, sir.
Okay, members of the board?
I'm good.
Okay, very good. I would entertain a motion.
Thank you, Mr. Chair. For Board of Building Appeals, case number 21-0047. The appellant is Stan Jablowski for Maumee Assembly and Stamping LLC and 920 Illinois Avenue LLC for the premises Maumee Assembly and Stamping at 920 Illinois Avenue, Maumee, Ohio 43537. The appellee is Jim Dussault, Deputy Chief of Fire Prevention for the Maumee Fire Department, and citation number 3773. I move to uphold the citation and assess a one-time civil penalty of $24,000 plus an additional $1,000 per month for each outstanding violation until all violations are corrected. In the event that the violations are corrected within 120 days of the date of this order, the entire civil penalty shall be waived.
Okay, I think that's been properly framed. Is there a second to that motion?
Second, Mr. Chair.
All those in favor signify by saying aye.
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 Any opposed? Okay, Ms. Worley, and Mr. Busick, the citation has been upheld with those attributes and conditions imposed to it. Is there anything else to come before the board?
Not from the city, sir. No, sir.
No.
Okay, very well, thank you. We stand adjourned on that case. Let's stay on the record real quick and let me read for purposes of the record that case number 21-0045, which is a division case, was continued for 30 days, so not heard today. Likewise, a division case 21-0051 has been continued to June 18th, likewise not heard today. And we had a Westerville fire case, case number 21-0030 that has been continued and again not heard today. I think before Paul jumped on and Neil was able to get on, Susan at least discussed with Brad and Chip and I some July date change. I think Chip has to get back with her on that. Susan, do you want to ask, where were we on that?
It looks like right now we could, Chip, I think everyone is available except I don't know on Paul for July 15th for our 1 day. And then we were looking at everyone except Chip. He was going to check into it, and Paul on 7/28 and 7/29, or for those 2 dates.
Here's what I would say. All of the things that I was holding out for June have been pushed back, so I have no idea. There are many things that are going to be popping up, and we have schools, new high school and new college starting mid-August, with high school athletics starting August 1st. So there's all kinds of stuff that's up in the air. So I'm sorry, I can't tell you, yes, do it. So what I would say is why don't we select a date best for the other board members, and I will let you know as soon as I can about my availability for them.
That's fine. I do with July 15th, Susan. I probably should check with my wife. I think I'm back the night of the 14th. But can we maybe, Paul and I'll just get back with you on that.
That's fine.
And Susan, as you're aware, we have our national convention coming up, and I chair one of the committees, so I'm going to be called to Annapolis 3 or 4 times upcoming before August, and they don't give me an option on that. When they schedule it, I have to go. So even if it's good now, it may not be good later.
Yeah.
Okay. Chip, were you able to check yet on the
I'm
28th?
not back from my assistant, so
Okay,
I'll let you know hopefully today.
okay,
And don't hold it up for me, because Lord knows it's a deposition and it could be an hour, it could be 8 hours. And it's not my client. I'm filling in for my office mate downstairs, so.
that's fine. I'll wait to hear back, Carl, from you on the 15th.
Yeah, but I'll know that today or tonight.
Okay, and I'll wait for
So
Chip.
Brad might be holding the hearings by himself.
Yeah, it will probably be in Reynoldsburg.
Okay, so that we don't have any other new business to take care of. Is there a motion to approve compensation for our preparation and our appearance today?
So moved.
Okay, all those is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Okay, we stand to be compensated for our efforts today. We've no minutes to approve, no new business. We're gonna get back with Susan on some dates. Is there a motion to adjourn?
So moved.
Okay, is there a second? Okay, there's a second. All those in favor say aye.
Aye.
Any opposed? Okay, we stand adjourned, subject to the announcement that our next hearing is scheduled for June 18th, 2021, beginning at 12:30, and is virtual at least at this moment right now. And otherwise, everybody enjoy your day. Tammy, thanks so much.
You're welcome.
Okay.
Thanks, everyone.
Have a good day, all.
Thanks.
Yeah.
Bye-bye.
You too. Thanks.